Hey, y'all. I don't know if you've been following the Stearns case, but we had an exciting event happen for Maddie in her favor the other day. Judge Keith Karsten denied Stephen Stearns' attorney's motions to suppress the cell phone evidence. Now, to put that into context, the cell phone evidence, the Google Drive, contained all of the images and videos of Stephen Stearns specifically abusing Maddie. If that evidence was suppressed, there would be no CSAM case. Yes, there was a USB drive with, I do believe, off the top of my head, 35,000 other images and videos. But from my understanding, in those videos and images, Stephen Stearns was not the perpetrator. Stephen Stearns was not on those videos abusing children. The photos and videos that showed Stephen Stearns abusing Maddie were all contained on his Google Drive and his cell phone. So if that evidence had been suppressed, we'd basically have no CSAM case. Let us all take a moment to be grateful and exceedingly appreciative that Judge Keith Karsten denied these motions. Now, today is the 4th of July. I hope that you are all enjoying the holiday with your family. Happy birthday, America. Plunder was able to get these documents. I have requested them, but today, as I just stated, is July 4th. It is a Friday. So before I would get my motions back, I would have to wait for today because the office is closed. They're obviously closed on Saturday and Sunday. So it appears that it would be at least Monday before I get my documents. Again, thank goodness for the wonderful YouTuber Plunder and also the Docket who got these documents. I am going to link them in the description box below. If you have not subscribed to them, please do so. You will not regret it. And with that, let's go ahead and read these motions. What did Judge Keith Karsten have to say about it? What is his reasoning? This document is the state of Florida as the plaintiff versus Stephen Michael Stearns, the defendant. And it is an order denying defendant's motion to suppress evidence obtained from unlawful searches of cell phone and motion to suppress evidence obtained from unlawful seizure of cell phone. I will let you know this is document one of two that she was able to get. The document reads, this matter came before the court upon defendant's, quote, motion to suppress evidence obtained from unlawful searches of cell phone, unquote, and, quote, motion to suppress evidence obtained from unlawful seizure of cell phone, unquote, filed on February 6th of 2025 and corrected on April 29th of 2025. The court having reviewed these motions, the state's responses, the arguments presented at the hearing on April 23rd of 2025, the court file, and being otherwise fully advised of the premises, finds as follows. The next subsection reads, motion to suppress evidence obtained from unlawful searches of cell phone. Defendant argues that the initial search of defendant's phone exceeded the scope of his limited consent. Specifically, defendant contends that while defendant consented to certain searches of his phone, the detectives exceeded the narrow scope of these searches. Warrantless searches are per se unreasonable, subject to only a few specifically established exceptions, citing Katz versus United States from 1967. While consent is one exception to the warrant requirement, the state has the burden of proving that consent was freely and voluntarily given, citing Scheckenkloth versus Bustamante from 1973. Under Florida law, the state must show by clear and convincing evidence that the defendant freely and voluntarily consented to the search, citing Bailey versus State from 1975. When consent is obtained after illegal police activity, such as an unauthorized search or arrest, the unlawful police action presumptively taints and renders involuntary any consent to search. There is no bright line test for determining the scope of consent to a warrantless search. Such a determination is made on a case by case basis, citing Allen versus State from 2005. The scope of the search is generally limited to what a reasonable person would have understood to be the object of the search during the exchange between the person and the police, citing Jacobs versus State from 1999. The state avers that defendant's argument depends on his misleading and incomplete recitation of the limited consent he gave to Detective Tangler. The court agrees. On February 27, 2024, Detective Tangler and Detective Acosta interviewed defendant at his residence. The detectives were in plain clothes, defendant was not in handcuffs, and defendant was free to leave. At 7:37 p.m., Detective Tangler asked permission to look at his Maps app in his phone. Defendant answered, quote, "Yeah, that's fine," unquote. Defendant willfully and voluntarily unlocked his cell phone and handed it to Detective Tangler. Detective Tangler soon thereafter asked permission to take a picture of his history. Defendant again consented. At 7:57 p.m., Detective Tangler asked again if defendant could unlock his phone so they could view its contents. Defendant willfully and voluntarily unlocked the phone. The detectives interviewed defendant a second time the following day. During the interview, Detective Tangler asked permission specifically to download his phone and asked defendant if he needed a warrant for his phone. Defendant again consented and provided the detectives his PIN number for his phone. No evidence suggests that at this point the detectives exceeded the scope of their search in any unreasonable manner. The evidence makes clear that defendant unlocked his cell phone and gave it to Detective Tangler on multiple occasions and unequivocally consented to them viewing map data and documenting his search history. Even after Detective Tangler asked if a warrant is needed, defendant nevertheless consented. Most importantly, defendant gave consent to law enforcement to, quote, download, unquote, the cell phone and to go, quote, through the phone, unquote. A reasonable person under the circumstances would understand the scope of consent to include access to all contents that were searched in this case, including call history. Furthermore, the evidence is clear that defendant was free to leave and that detectives interacted with him without coercive tactics. Consequently, the state has established by clear and convincing evidence that defendant freely and voluntarily consented to the searches and that law enforcement did not exceed the scope of defendant's consent. The next subsection is titled Motion to Suppress Evidence Obtained from Unlawful Seizure of Cell Phone. Defendant contends that his cell phone was unlawfully seized by Detective Tangler for over 9.5 hours without consent or probable cause. To support this claim, defendant asserts that Detective Tangler made no attempt to obtain a warrant despite the availability to do so. The evidence demonstrates that Detective Tangler had probable cause to believe there was evidence of a crime contained in defendant's cell phone at the time of the seizure. Probable cause requires a practical, non technical probability that incriminating evidence is involved, citing Texas versus Brown from 1983. Probable cause only requires that facts available to an officer would warrant a person of reasonable caution in the belief that certain items may be useful as evidence of a crime. I'm going to stop here and let you know that I'm going to fill in what I believe to be the redacted words on this document using the context of the sentences around the words. Continuing with the document. As the state correctly points out in its response, at the time of seizure, Detective Tangler knew that Maddie had been missing for over 24 hours, and defendant was consistently identified as the last person to have seen Maddie prior to her disappearance. Additionally, law enforcement had tag reader evidence that defendant was not being truthful with regards to his movements on February 26, 2024. Defendant also regularly used his cell phone to speak with Maddie. Consequently, the court finds that the facts available to Detective Tangler after consensually searching defendant's phone is evidence that would warrant a person reasonable caution in the belief that the phone may be useful as evidence of a crime. Furthermore, Detective Tangler had exigent circumstances to seize the phone. The test of whether exigent circumstances exist is an objective one, citing United States versus Tobin from 1991. Whether exigent circumstances exist is a fact specific inquiry that depends on the totality of the circumstances, citing United States versus Aureliano Olcha from 2006. The fear of imminent destruction of evidence must be objectively reasonable, citing State versus Darter from 2022. Specifically in determining whether state agents reasonably feared imminent destruction of the evidence, the inquiry is whether the facts, as they appeared at the moment of entry, would lead a reasonable, experienced agent to believe that evidence might be destroyed before a warrant could be secured. Here, evidence shows that Detective Tangler had an objectively reasonable fear that the cell phone would have been later destroyed prior to securing a warrant. Detective Tangler, based on the answers of defendant, had a reasonable belief that he had attempted to destroy cell phone evidence by factory resetting it at some point during that same day. The destruction of the cell phone was also likely more imminent after meeting with Detective Tangler and Acosta, given that he knew he was under suspicion and they showed interest in his phone because law enforcement was under the reasonable belief that destruction of cell phone was imminent and they had probable cause to believe there was evidence of a crime contained on the cell phone. Detective Tangler's seizure of defendant's phone was lawful. Accordingly, it is hereby ordered and judged that 1. Defendant's motion to suppress evidence obtained from unlawful searches of cell phone is denied. 2. Defendant's motion to suppress evidence obtained from unlawful seizure of cell phone is denied. Done and ordered in chambers in Osceola County, Kissimmee, Florida, this first day of July 2025. While I grab this other document, again, let us thank goodness that Judge Keith Karsten decided to rule that way. Maddie got a win July 1st in court. Second document. State of Florida as the plaintiff versus Stephen Michael Stearns, the defendant. This is a order denying defendant's motion to suppress evidence obtained from Google search warrant. Keep in mind again that everything obtained from the Google search warrant is going to be all the pictures, videos, and images of Madeline. See, they first had to get his phone. So that's what the first issue was about. The order denying all of that. They're saying that the detectives obtained the phone legally, they searched the phone legally, and now we're going over why it was legal for them to search his Google account, which is where all of the abuse of Maddie was contained in video and photo format. It reads, this matter came before the court upon defendant's, quote, motion to suppress evidence obtained from Google search warrant, unquote, filed on February 6th of 2025 and corrected on April 29th of 2025. The court, having reviewed the motion, the state's response, the arguments presented at the hearing on April 23rd, 2025, the court file, and being otherwise fully advised of the premises, finds as follows. Analysis and ruling. Defendant contends that all evidence obtained through the Google warrant must be suppressed. To support his claim, defendant makes three main arguments. This subsection is titled 1. Google warrant relied entirely on illegally obtained evidence. Defendant first asserts that law enforcement exceeded the scope of Mr. Stern's initial consent retained his phone without proper authorization, and conducted a coerced midnight download. Because law enforcement used the information extracted from the searches to support the application for the Google warrant, defendant alleges the state cannot justify the warrant under any attenuation or independent source doctrine because the warrant was built entirely on tainted evidence and intentional misconduct. Defendant concludes that the evidence must therefore be suppressed as fruit of the poisonous tree. Defendant fails to establish that his searches were coerced or otherwise improper. The evidence makes clear that defendant willfully and voluntarily unlocked his cell phone and gave it to Detective Tangler on multiple occasions and unequivocally consented to them viewing map data and documenting his search history. Even after Detective Tangler asked if a warrant is needed, defendant nevertheless consented during interviews. Most importantly, defendant gave consent to law enforcement to quote download unquote the cell phone and to go quote through the phone unquote. A reasonable person under these circumstances would understand the scope of the consent to include access to all contents that were searched in this case, including call history and GPS data. During interviews with law enforcement, defendant was free to leave. Consequently, defendant freely and voluntarily consented to the searches and that law enforcement did not exceed the scope of defendant's consent. The state is therefore correct in its response that law enforcement relied on information properly obtained during consensual searches of defendant's cell phone to support the affidavit for search warrant. Consequently, the warrant at issue was not tainted and was not constitutionally invalid as fruit of illegal searches. Subsection 2. The warrant application fails to establish probable cause. Next, defendant asserts that the warrant application fails to establish probable cause. To establish probable cause, a supporting affidavit for issuance of a search warrant, quote, must satisfy two elements. First, that a particular person has committed a crime, the commission element, and the second, that evidence relevant to the probable criminality is likely located at the place to be searched, the nexus element, citing Sanchez versus State from 2014. A magistrate is not required to leave common sense at the courthouse door when evaluating whether a supporting affidavit satisfies the nexus element and supports a finding of probable cause, citing State versus Williams from 2010. The next two paragraphs has redactions, and I'm going to fill in what I believe the redactions to say using the context around the redactions. Continuing with the document. Here, the affidavit for search warrant for defendant's Google account provided a sufficient basis for the court to determine that evidence related to child pornography would likely be found on defendant's Google account. Specifically, the affidavit points to the fact that defendant factory reset his phone the same day Madeline was last seen. Detective Heller also indicated that interviews of defendant were conducted and that defendant consented to a search of his phone. During the search, several files of, quote, child sexual abuse material involving Madeline, unquote, were located. Furthermore, the affidavit stated that defendant's images were stored and backed up on his Google account. Additionally, the affidavit further describes that evidence related to interference of child custody was contained within defendant's Google account. Detective Heller detailed that Madeline was reported missing by her mother on February 26th of 2024. Defendant has stated that he dropped Maddie off at Peace United Methodist at 8:40 a.m., although classes did not start until nearly an hour later. However, a license plate reader captured defendant's vehicle tag traveling away from Hunters Creek Middle School at 8:10 a.m. Madeline never showed up to school. The state is correct that at the time the warrant application was filed, it was probable that other information on defendant's cell phone prior to the factory reset was backed up to his Google account, such as GPS data, which was described in the affidavit for search warrant. Based on the ample evidence which was relevant to the probable criminality likely located on his phone, the warrant application sufficiently established the nexus element. Consequently, the warrant application was backed by substantial evidence satisfying both prongs of Sanchez. Defendants claim that the warrant failed to establish probable cause is therefore without merit. Defendant further argues that the warrant was overbroad in its time frame for searches. The warrant permitted the search of data from January 1st of 2020 to present, yet, according to defendant, provided no factual basis for the expansive 4-year period. However, courts often note that child pornography collectors maintain their materials for significant periods of time, citing United States versus Perrine from 2008. Here, there is evidence to support that defendant was an individual that fell into this category, given that the material was his stepdaughter and that it was located on his phone and backed up onto his Google account. Accordingly, the warrant is not tainted for having an overbroad temporal scope. The court also notes that the warrant affidavit was not overly reliant on generalized and boilerplate language about Google services. The state is correct that the implementation of standard language in the search warrant related to the operations of Google LLC is helpful and relevant in the affidavit. The boilerplate language was accompanied by ample case specific information. Subsection 3. The warrant lacks required particularity for digital searches. In his final argument, defendant contends that the warrant lacks required particularity for digital searches. Defendant avers that the warrant's authorization to search, quote, any and all stored electronic communications or files, unquote, associated with the Google account is impermissibly broad in violation of the Fourth Amendment. To support his claim, defendant cites Riley versus California from 2014. However, Riley is inapposite. In Riley, the Supreme Court of the United States held that a warrantless search of a cell phone seized incident to an arrest must generally be suppressed. Riley does not address in a relevant and detailed manner how search warrants must be particularly detailed when authorizing searches of digital data. The state cites to United States versus Lamb from 1996. In Lamb, the defendant challenged the particularity of the warrant when it sought, quote, all stored files in original format in individual files, unquote. The Northern District of New York noted that although the language does not limit the investigators to seizing only files of child pornography, the court noted that, quote, the actual content of a computer file usually cannot be determined until it is opened, unquote. The court held that the motion to exclude the pornography from the trial was denied. Moreover, the court agrees with the state that even if the warrant was impermissible as overbroad, the quote, good faith exception, unquote, nevertheless applies. The good faith exception applies when a law enforcement officer acting with objective good faith obtains a search warrant and acts in accordance with the warrant and scope. Suppression of the evidence obtained is not appropriate even if the court later determines that there was no probable cause. Citing United States versus Leon from 1984. Exclusion of the evidence is appropriate in cases in which the affidavit is so lacking in probable cause that reliance on it would be unreasonable, citing Brown versus Illinois from 1975. Here, law enforcement did not provide any false or misleading information in the affidavit for search warrant, As stated throughout this order, the affidavit was not lacking in reliance, so law enforcement relying on the warrant was not unreasonable. Accordingly, the court finds the good faith exception applies and suppression of the evidence is inappropriate. Accordingly, it is hereby ordered and judged that 1. Defendant's motion to suppress evidence obtained from Google search warrant is denied. And it was done and ordered in chambers in Osceola County, Kissimmee, Florida, the first day of July 2025. What an amazing victory for Maddie. The CSAM trial is scheduled to happen July 22nd, and judging by the fact that there was a joint motion to continue filed, and even with that, Judge Keith Karsten only continued the trial by about 7 or 8 days. I would think that it's definitely going to start on July 22nd. I will be streaming the trial every single day if you guys want to check that out and watch it with us, with the speculating family. If you have not subscribed, please do so. Please hit that thumbs up. Make sure your notification bell is on so I can get you updates as soon as I am able to obtain them. And furthermore, if you have not subscribed to Plunder or the Docket, please do so via the links below. Thank you so much for watching. Happy 4th of July. Have a wonderful weekend.